Welcome to Law Tellers. Today we're going to examine a decision by the Supreme Court wherein the matter that was considered was what are all the materials that a magistrate can look into at the stage of discharge under section 227 to 38 CrPC. The case itself was is the CBI versus Elluri Srinivasan. Newton citation is 2025 INC 758. Now, the offenses alleged under this particular case was section 120B 420, 13 subsection 2, and 13 subsection 1D of the Corruption Act. In this case, the A1 was a government servant in the government agency, and the son A3 was a businessman, and both of them colluded to take cotton from the farmers, purchase below minimum selling price. And when the government started buying cotton at MSP, A1 and A3 resold these cotton which are hoarded by them at a higher MSP rate, and thus they have caused a wrongful loss to the government. Start the accused under section 239, the ground of no prima facie case. The Supreme Court in appeal said that the court is not to examine any material other than the final report and other materials produced along with it under section 173 of CrPC at the stage of section 239. The court approved the dictum in the state of Odisha versus Devendra. When it was held that the accused at the stage of framing of charge does not have a right to produce material or documents. Also, the division in state of Maharashtra and Priya versus Priya Sharan. It was held that under section 227 to 28 state, the court is required to evaluate the material and documents and report the view to finding out the facts emerging therefrom, taken at the face value, disclose the existence of ingredients constituting the alleged offense. And only if there is a prima facie the existence of a case of facts, only then the case could move forward. Otherwise, the option under 239 could be exercised and discharge from the case. The court said that roving and fishing inquiry at the stage of framing of charges is impermissible. The court, quoting the phrase in the consent provision, that is, hearing the submissions of the accused, does not mean opportunity for the accused to file material. The court quoted with approval the dictum in Rajasthan versus Swansea, where it was held that the accused does not have the right to invoke section 91 of the CrPC at the time of framing of charge. Section 91, if I'm not wrong, concerns the seizure of material from at the instance of court from wherever it is wherever the court believes it fit to be seized. The court is provided with the discretion under section 237 or 239. The court said that the inner and outer limits of the discretion under these sections are provided by few of the cases mentioned hereafter. Firstly, in Shivraj Singh Pahlavat versus State of UP was observed that the inconsistency in the material produced by the prosecution cannot be looked into for discharge of the accused. And in Madhya Pradesh versus State of Madhya Pradesh, where Rakesh Mishra was held that only the charge sheet along with the accompanying materials had to be considered at the stage of framing of charges. And thirdly, in State of Rajasthan was Ashok Kumar, The Supreme Court reiterated that beyond debate that defense on merits is not to be considered at the stage of framing of